Midterm on the Beatles? Midterm on the soundtrack for MS-104A. Well, I'm happy to announce that the Pat Brown Cafe is open for business today, first day. And they make a pretty good cappuccino. It's Peet's Coffee. So that opens up infinite possibilities for office hours, either before or after class, if you let me know ahead of time. It's a good place to meet. I don't think I did a very good job last time in explaining or trying to understand Justice Goldberg's point in his concurring opinion in New York Times versus Sullivan, where he, it's clear, thinks that libel suits by public officials because of criticism of the way they perform their official duties should be abolished, should not be permitted under the First Amendment at all. And he took the court's statement that libel on government has no place in our system and turned that back on the court, saying that government's not an abstraction, it's made up of individuals, governors responsible to the governed. And in a democratic society where we can remove those who are in power, criticism of governmental action is necessarily of and concerning the governors. So that any statement critical of the governor's official conduct is necessarily of and concerning the government. It was the notion floated by the Supreme Court of Alabama to satisfy the of and concerning requirement. Then Goldberg turns around and says that, well, if the rule that libel on government has no place in our Constitution is to have real meaning, then libel on the official conduct of the governors likewise can have no place in our Constitution. Robert? That's a good question. It certainly has broader application than to elected officials. How about a justice of the Supreme Court, for example? Not elected, appointed by the president. It certainly has broader application than to high-ranking officials, although that would be relevant to a determination of whether somebody will be treated as a public official. On the other hand, it doesn't go so far as to reach everybody who happens to be on the public payroll. For example, there are lots of employees, staff, and faculty at the University of California at Berkeley who are on the public payroll. Are they public officials? No, not really. What about the cop on the beat? The policeman out there doing his or her job. California courts treat police officers as public officials because they have some power over other individuals and some discretion in applying the law. And so, am I a public official? I don't think so. Just because I'm on the payroll of Berkeley doesn't make me a public official, and I don't think I wield enough power even over you to be treated as a public official. But I don't think there's a clear answer to that question, just as there isn't a clear answer on public figures, which we come to next. Because the case that the most important libel case since Sullivan was the case of Gertz versus Welch 10 years later in 1974, where the court was faced with the need to put some flesh on the bones of what are we going to do about public figures, public officials, what do they have to prove, and so on. And Gertz was a lawyer in Chicago, a fairly prominent lawyer who had served on a mayoral commission at one point, and at that point he was a public official, but that was in the past. Well-known lawyer, and he represented the family of a young man who was killed by the police and brought a lawsuit on their behalf against the city of Chicago. Robert Welch, was a right-wing conservative, the head of the John Birch Society, and they put out a newsletter, magazine kind of thing, in which they attacked Elmer Gertz, as being basically a communist, dishonest, unethical, ambulance chasing, said a lot of unkind, defamatory things about Gertz. And the litigation dragged on for a long time, and then went to the Supreme Court with one of the principal questions being, is Gertz a public figure? He was no longer a public official. Is he a public figure? And if so, then what does he have to prove? We know from the cases following Times versus Sullivan, that is the Butts case and the Walker case in 1967, that public figures will be treated the same as public officials. But what's Gertz? And the court undertook to define categories of public figures. And one category of public figure is the pervasive public figure, or the all-purpose public figure. These are household names. Everybody knows who these people are. These are the Oprahs, the Sarah Palins, the Mark Zuckerbergs of the world, who are going to be treated as public figures. And therefore, if they sue for libel, they'll have to prove constitutional fault, actual malice. Well, Gertz clearly wasn't in that category. Just simply a prominent lawyer in Chicago did not make him an all-purpose public figure. Then the question is a different category of public figure, the vortex public figure, or the limited purpose public figure. And that's someone, the court said, who voluntarily thrusts himself or herself into the vortex of a public controversy, into some issue that's in the public eye, gets prominent with respect to that issue. Then that person will be treated as a public figure for the purpose of discussion about that issue, whatever it is, automobile safety, drugs, you name it, what the issues of the day. If this person has written something on it, appeared in public on it, spoken out online on the issue, gone to bat for one side or the other, that person becomes a limited purpose public figure, limited to the discussion of the issue that they've injected themselves into. And then the court says, this is an opinion by Justice Lewis Powell, and then the court said there may be a category of involuntary public figures, that is, individuals who get caught up in some controversy through no fault of their own, and not desiring to go out in public at all, but they've come into the public attention because of some event. He said there may be a category of involuntary figures. I think it's fair to say that there is a category of involuntary public figures, people who accidentally are thrust into the public eye. For example, people who are accused of crime and who are arrested for some high-profile crime. They didn't seek the public eye by any means, but there they are in it. And that would include not just robbers and rapists and so on, but these politicians and securities fraud people, the Bernie Madoffs of the world and so on. Hostages, for example, might become public figures. And there are a number of other kinds of individuals who might be considered involuntary public figures. The court determined that Elmer Gertz was not a public figure, though he was prominent in Chicago, that he had not voluntarily injected himself into the vortex of any particular controversy. His representation of the family of the boy who was killed by the police was not sufficient to make him a public figure, so that he didn't have to prove actual malice, didn't have to prove constitutional fault. And the court addressed the question of what kind of fault must be proved by a private figure, somebody who's neither public official nor public figure, and determined that even a private figure must constitutionally, the First Amendment requires this in order to give breathing space to discuss the issues of the day, even a private figure must prove some degree of fault, some blameworthy state of mind on the part of the publisher of the defamatory statement. That degree of fault, the court said, must be at least negligence. That is, that the speaker and the publisher did not act as a reasonable publisher would in the circumstances. For example, wrote the story relying on an anonymous call from an unknown drunk. If you write the story based on that kind of source, that would be considered negligence and result in liability. But the court left up to the states the degree of fault required, whether it be negligence or actual malice or something else, although I don't think anybody's thought of anything else. And so the states individually have determined for themselves what degree of fault private figures must show. Most of the states, including California, have chosen to require negligence for private figures. Some of the states have gone all the way and said across the board, libel suits, actual malice must be shown. Whether it's public figure, public official, or private figure, actual malice must be shown. So after Gertz versus Welch, there is no such thing as a no-fault libel tort anymore. Everybody has to show some degree of fault, at least negligence. When Sullivan was, I should say that on the subject of what is actual malice, the court has used this formulation. It must amount to a subjective awareness of probable falsity. That's the gloss that they put on the definition of constitutional fault. It still requires knowledge of falsity or reckless disregard for the truth. But one shorthand way of saying that, they must have had a subjective awareness of probable falsity in order to be held liable for libel. When Sullivan was decided in 1964, one of the great First Amendment lions, one of the great First Amendment scholars, Alexander Michaeljohn, who believed that political speech is absolutely protected under the First Amendment, that there's no grounds on which political speech may be restricted. But that's all he was interested in, was political speech. He did not believe that art, for example, music, poetry, literature, all kinds of expression was protected by the First Amendment. The First Amendment was meant only to serve the needs of a democratic society in facilitating public discourse, and he believed that for that purpose, political speech was entirely protected. When Sullivan was decided, Michaeljohn said, this is an occasion for dancing in the streets. This is a charter of liberty for free speech in our democracy. I think that was a little over-enthusiastic, given the court's adoption of the actual malice standard. Instead of going all the way that the court's logic would have taken them and done away with libel suits by public officials, Brennan stopped short, detoured, said, no, public officials can sue as long as they prove actual malice. Well, as I said the other day, that opens up the whole subject of how every allegedly libelous statement was manufactured, how it came about, how the story got written, with an excruciating examination of the reporter, the editor, the publisher, the witnesses, the sources, whether they're confidential or not. And that is an extremely expensive proposition that the press has to endure attributable to the actual malice rule. So while it's true that the principles, the First Amendment principles established by the Sullivan decision are wonderful, bedrock of our free speech culture, in practical effect, the decision may not be an occasion, at least for the press, to be dancing in the streets. And that raises the question, is this decision based on freedom of the press in the First Amendment? Is this a press case? Tina?
They do say that false speech isn't, unprotected outright. But it seems to me that the rest of the decision is saying that false speech, libel is tolerated only insofar as it protects free speech. So they're kind of privileging this idea of the truth through allowing there to be just enough falsity to not get in the way of that. So kind of opens a gray area of how much freedom we're going to allow the press to have to make sure that the right statements are allowed to flourish.
That's one way of looking at the Sullivan decision and the Gertz decision. And it happens to be the way that the government looks at it in the Alvarez case, the liar case that we'll talk about in a minute. But you didn't say anything about the press.
The press kind of has to, they don't necessarily have the absolute freedom to say whatever they think is right. They have to word it out
The question is, does it put the press in a different situation than you or me or anybody else who wants to say something? Yeah. But Mark, did you have something?
Yeah, I was going to say, now that I think that the press is given a decent amount of power because now it's defined what's public figure, like now you know what the basic figure is, like that, then, and do I stand before the more gray area. I think that's, not only does it apply to the press, also applies to individuals. That means if I want to start putting up pamphlets, just kind of talking about certain politicians or actors or whatever, I feel like I would still have some protection as well, because individuals be press based on that.
And then it's the other Mark, right? Yeah.
Yeah, so for any part of the press, I was thought it was more like taking that approach to it, and that's because there was some like falsity to it.
Somewhat? Falsity? Yeah.
Like that doesn't make way to correct that, like criticism or whatever. They seem to stress that how important it was to have that ability to be those minds.
Yeah.
Like the whole interpretation, like part of Alabama's like case was that the commissioner was directly related or like criticizing the comments because he was like a head official, he was getting criticized and that was something that the jury would automatically connect.
Mm-hmm.
Like that was the biggest argument there that report that.
Well, to what extent does that idea apply to the press or exclude the press? I mean, is this a press case? If you look at the Black's concurring opinion, for example, he's talking about freedom of the press, and the press is doing exactly what it ought to be liberated to do whatever. I mean, he's talking about freedom of the press. But Brennan wrote the majority opinion, and the question is this a decision that turns on those 4 words in the First Amendment, or of the press? Congress shall not abridge the freedom of speech, or of the press. Is this a press case or a speech case? Yeah.
Throughout the entire case, it wasn't just focused on the press. They sued the civilians who submitted the ad. So they weren't just saying, oh, we're targeting the New York Times because they have access to all these people. There are people in the press. They were including citizens in that too, so it applies more broadly to speech in general, not just to the press.
Yeah, it's a good point about the fact that they sued the 2 preachers from Alabama, who were not the press, were also sued, and were also let off the hook from liability by the court's decision. All right?
I think it's the best because ultimately what the New York Times decides to publish, they are responsible for. If when they decide on what to act, because we're saying it's an act, right? It wasn't an op-ed, it's an act. The New York Times keeps in their best interest to make sure the companies that subscribe to ads in their paper go along with their idea. So they're not going to publish an ad for a company. While they will get revenue from that, it's not in their best interest to publish an ad for a company that they are against. That's the company themselves. So my point is that if they are to publish like something that's not in their best interest, they wouldn't publish an ad for it.
So are you suggesting that whether they're free constitutionally to publish something, it makes a difference whether it's an ad as opposed to their own editorial product? Well, everybody thinks of Times versus Sullivan as the most important press case ever, the most liberating decision for the press in American history. But I'd suggest that if you look at Brennan's opinion, you won't find anything there that says we're relying here on the freedom of the press protected by the First Amendment. The reasoning of the decision, the heart of the decision, is the Madisonian premise that Brennan refers to, the premise that we, the people, are in charge here. We are the sovereign, not the people who are in government. And we, as citizen critics of the government, have the right to criticize it or to criticize public officials. The decision seems to me to be premised on that notion that we citizens have to be allowed to criticize government. Not that the press has some special protection or some special status which liberates the press and treats them differently than all of the rest of us. It's somewhat curious why the court did not go the whole distance and abolish suits, whether against the press or against individuals like the preachers in Alabama or anybody else, any one of us who criticizes government. Why the court didn't go the whole distance and do that. And as I suggested Tuesday, at least Justice Brennan was concerned that doing so would allow deliberate lies. And he was unwilling to countenance a system, a First Amendment principle of permitting people deliberately to lie. And that takes us to the liar case, the Alvarez case. Javier Alvarez has told a lot of lies. He has lied about